here in Bihar. Three orders. Could I show your lordships the order of...
Sir, show all these things before the NGT or the Central Pollution Control Board.
Who
will take action against the persons who has violated?
Pollution Control Board would not, but the nodal agency REC could. REC would.
No, why Pollution Control Board will not inspect the whatever the production and other things?
Production with regard, what it has been said is, whatever be your lordships' direction, could I show your lordships 1 or 2 pages, only for, or if your lordships feel I am wasting my lord's time in view of him.
Don't waste your time and ours.
But
we can concentrate on some other case.
Could your lordships keep it tomorrow? I'll take an instruction also.
Learn counsel for the petitioner after arguing for some time. Time to get instruction from his client. This matter, Monday.
Friday,
Friday.
Right. I'm reminded of judgment of the Supreme Court in आपके खिलाफ.
मेरे खिलाफ your lordship decided that NIT on 20th of April on Monte Carlo case. That is that very.
I'm neither for a bidder nor I am not even a bidder.
You are a manufacturer.
Please. I have as a Rune Enterprises challenged similar clauses in Punjab in the year 2022.
And I don't know.
I have an extra record. I have on affidavit put the order sheet. And notwithstanding that, you are making allegations.
You have made false statement, non-degradable. Plastic, no word.
2022 orders
totally
by the name of the same petitioner in the High Court of Punjab and Haryana.
You have already expressed a tentative.
No, sir, I
not going to entertain.
No, sir.
Get instruction.
No. I was talking about a 2015 Supreme Court judgment wherein possibly the only place I found 10 paragraphs of discussion between advocate and a client.
The counsel, why don't you go and give complaint to the NGT? They will impose a cost in crores.
No, sir, I have taken your lordship's view.
Number 33, Narendra Kumar versus the State of Bihar for the distancing to
Next party order of blacklisting. They filed counter affidavit. There is no denial, and there is very peculiar facts of this case. That the order of
my lord, what I am submitting, my lord. I am conscious of the fact, my lord, that so-called notice has not been given. I may be given liberty to proceed in accordance with law because he has done so many things, my lord. But notice has not been given. But liberty may be given.
Sir, as prayed for the following relief. So, one of the contention raised in the present petition is before blacklisting the petitioner for a period of 10 years in terms of
Bihar Contractors Registration.
Bihar Contractors Registration Rule 2007. He has not been heard in the matter. In other words, show cause notice has not been issued. Not disputed by the land counsel for the respondent. In the light of these facts and circumstances, the petitioner has made out a case accordingly. Letter number 186, dated 14/3/2023. Insofar as blacklisting the petitioner for a period of 10 years is hereby set aside, writ petition stands allowed, reserving liberty to the concerned respondent to proceed in accordance with law. The concerned respondent is hereby directed to take note of apex court decision in the case of UMC so and so, read with isolator so and so, before taking further action.
Your Lordship, in bill number 34, Your Lordship, this is the third time he has taken adjournment without consent.
What is the date given? 34?
So it is matter for 10th of May, my lord.
On 10th of May, you be here by 10:30.
Yes.
Then he will not commit such mischief.
Let's kindly permit me to mention, Millard, it's a writ application, Millard, by the order dated 29/9/2022, Millard, it was directed. Is this case on 10/11/22, Millard, and it has not been listed yet. I have annexed the order.
With permission.
Lordship, may I permit to mention, Your Lordship? This is a writ application, Your Lordship. It was admitted for hearing. It was listed for a while, but now it is out of the list, Your Lordship. We have filed
Make an application.
We have filed an IA application, My Lordship.
IA list karo.
Millard, sorry. Okay. On contempt matter, Millard, order passed by my lord. Contempt matter, Millard, order passed by my lord has not been complied with.
With permission, my lords. 62 CL, my lord. PWJC double.
Outside list, Your Lordship, may I be permitted to mention a case which has been heard by my lord at length, and it seems to be the Pathad matter. The report was called from the SP, and they have submitted the report that, Your Lordship, may kindly recollect the posting of Chowkidar, SP, DSP, everyone was called, and Your Lordship asked them to submit the vacancy report. They have submitted the vacancy report. Urgency is that next year he will attain the age of superannuation, and Your Lordship have heard this matter.
My lord, I may be permitted. My lord, I may be permitted to mention a case. My lord, it is a contempt matter. My lord, order passed by my lord.
Contempt.
Your Lordship, you want contempt matter, my lord.
You are also out of contempt matter, my lord.
Your Lordship, one hearing matter, Your Lordship, on the last of it we have mentioned, Your Lordship, directed to file an IA, Your Lordship. We had already filed an IA for early hearing, Your Lordship.
My lord, with permission, my lords. My lord, one writ application, procedure 62, my lords. My lord, this
लिस्ट वाला बात में सर हम जब कॉल करेंगे
I mention a case, my lord, admitted case, my lord, hearing matter, my lord, for listing, my lord. Only for the purpose of listing, my lord. Yes, my lord.
Next application.
IA file है
Right, my lord.
Now from the list, any general between serial number 1 to 7.
My lord, item number 2 is the reply.
The for the petitioner.
My lord.
Any general between serial number 8 to 16. Any general between serial number 17 to 26. Any general between serial number 27 to 33.
That's 33, Millard. I pray for Passover, Millard. That's only due to some personal difficulty, Millard. I pray for only for Passover, Millard. I've taken the consent also.
Your Lordship, with regard to item number 28, Your Lordship, I may be permitted to withdraw this 28. Right.
36, one victim.
Any general between serial number 34 to 38.
Good.
Any general between serial number 39 to 47. Any general between serial number 48 to 55. Any general between serial number 56 to 63.
my lord, regarding 62, my lords. This case in serial 62, my lord. My lord, this matter is related to salary matter. And respondent has not given the salary petition 25 years, my lord, from 1998 till today. My lord, just my prayer, my lord, this case can be heard. If not today, then next Wednesday, because respondent is not present.
How can I say that whether the matter could be taken up today or not?
My lord, this is an urgent matter.
Huh?
This is urgent matter, my lord.
Urgent means wait.
Salary has not been.
All right, sir, wait for your turn.
Any general between serial number 64 to 67. Under the heading to be mentioned, item serial number 1, Rajesh Kumar versus the State of Bihar for the petitioner Sri Kundan Kumar Sinha.
Lord, my prayer would be, my Lord, item number 1 and 25, my Lord, may be heard together, my Lord. Because the similar nature of case, my Lord, and the order has been complied with, my Lord, now in between the 25.
Who is appearing for 25?
My Lord, they were both, my Lord, the petitioner, my Lord, and the order has been complied with, my Lord.
Right.
Yes, my Lord, yes.
Counsel for the respective parties, my instruction submitted that they present MJC the concerned respondent has complied the order. Accordingly, the present LJC stands dropped.
The additional so cause may be kept on record, my lord.
And 26.
I filed also, my lord.
Focus in which?
Lord, in item number 1 and 25 both.
First, you mentioned that focus is dated so and so taken.
Obliged.
125.
Serial number 2 is adjourned for 2 weeks. Serial number 3, Ravi Bhushan versus Mr. Ravi Parmar.
Your Lordships, in view of your Lordship, direction file reply to the counter, so-called Lordship. And if my Lord will, I will, Lordships, will be of it that has not been complied, Lordship. I have given a specific statement. If my Lord will say, yes, Lordship. My Lord's order as is at Annexure 1, Lord, contempt application. Page number 11.
The salary has not been paid.
Lordship, may I submit one thing, Lordship? What happened after while hearing this case, Lordship? I had sought for two reliefs, Lordship. For setting aside the letter dated 7/6/2000, Lordship. My Lord has refused. My Lord has dismissed the writ petition, Lordship, and also relief was sought for that half salary should not be deducted as per the letter, Lordship, because the mother was being paid half salary of the petitioner, Lordship. My Lord has dismissed my writ petition, Lordship. But subsequently, in this para number 4, my Lord has gave some observation, Lordship. That with great respect, Lordship, it seems some typing mistake, maybe, Lordship, because I have clear in my reply to the
Sir,
concerned respondents are permitted to pay full salary from 3 years prior to presentation of petition. Lordship, there was no such relief sought for by the petitioner, Lordship, regarding.
No, there is a delay. Therefore, we have restricted this. There is a delay on your part in claiming the salary.
Lordship, salary was being paid, but it was as per the order of the department. After payment, 50% was paid.
The reasons for restricting the 3 years prior to filing this petition is that you approach this court belatedly. This is in terms of principle laid down by the Supreme Court in the case of M.R. Gupta versus Union of India.
Then, Lordship, if my Lord's observation.
Sir, we can't reopen the issue now.
I'm not requesting. I'm not submitting for the reopening, Lordship. Then it will be presumed that petitioner is entitled for the full salary, Lordship.
Huh?
Yes, petitioner is entitled for the full salary, Lordship. But once petitioner is entitled for the full salary, Lordship, then the consequence of letter 7/6/2000 has gone. They are issuing.
Have they paid you salary or not? Yes. Prior to filing of this petition, 3 years prior to this.
Lordship, salary was being paid since the joining of the petitioner, Lordship, in the year 2000. When the
Mr. Counsel, please understand, this writ petition was filed in 2021.
Okay.
Prior to 3 years means how much? 2018. Have they not paid 2018?
Lordship, salary was being paid since 2002, in the year 20, Lordship, 2000, Lordship. When the Annexure 1 was issued, Lordship.
Sir, have they paid you from 2018 or not?
It was not in dispute that they were not paid, Lordship. They were paying since joining of the petitioner, Lordship. It was not in dispute, Lordship. They were after payment, Lordship. They were.
Then how the contempt survive if they are paying?
Lordship's contempt survived because my Lords have given order.
No, sir, the specific order is only payment of full salary for the 3 years prior to filing of this petition. Can we go beyond that?
And will continue. And my Lord has pay to continue. Lordship, if my Lord's order is obeyed in total, Lordship, then the order of 7/6/2000 has gone, Lordship. They will have to pay, and they have.
Sir, that is the reason we are asking you. You have been paid from 2018 or not?
Lordship, I am being paid since 2000, not 2018, Lordship.
Then it is. Then you are in a better footing.
Lordship, better.
They have extended you beyond the period mentioned.
My relief why not this that they are not being paid, Lordship. They are paid, but after payment they.
File LPA, sir.
Lordship,
file LPA.
And my Lord's order in LPA, not I have. They have filed LPA, Lordship, against this order.
Yeah.
State has preferred LPA, Lordship.
But still we have complied, Your Lordship.
State has preferred LPA.
Alright, if you are aggrieved by my order, you file LPA, sir.
Lordship, I am not aggrieved. It is a state who are aggrieved and they have filed LPA, Lordship. My submission is only that.
Sir, we are concerned with only content, sir.
My Lord.
Sir, have they complied or not?
They have not.
2018 salary has been given you or not?
But they are deducting. This is my case, Lordship.
Where is that rejection?
Yes, Lordship. They have not.
Where is the rejection from 2018 to this date?
Can they see annexure?
Where is your shocker?
Annexure 6, 7, 8, 9, Lordship. They have not replied regarding that.
Second supplement.
Pursuant to Your Lordship's order 12/4/2023, we have filed second supplementary show cause, and we have
On 5/4/2023.
Lordships.
5/4/2023.
It was filed on 24/4/2023, Your Lordships. Second supplementary show.
Where is the statement?
Lordships.
They have not denied, Lordship. And they are not issuing letters.
No, where is the statement of payment of salary?
Lordships. The chart we have annexed.
Where is that?
Page 11 of the second supplementary show cause. And prior to that, we have also furnished a detailed chart page.
No, why you are paid from 4th February?
No, page annexure A, Lordship, starts.
Page 19.
No, it is not page 19. Annexure A, page 10. This is I'm submitting from annexure, Your Lordship, the second supplementary show cause.
Page 10.
10. This is the chart.
Actually, chart commences on page number 6.
Then paging.
You are paid from 17th April?
Lordship, yeah, we have paid from August 2010 to
payment made during the 2018.
It is there, Lordship. It is in the chart itself.
Chart from page number 6, it is not there.
Probably then paging is missing, Your Lordship. I am sorry.
Lordship, kindly see my.
No, surely you put a flag. 2018.
So this is the reply to the show cause which they have filed.
And it shows, sir, from 2018 you are paid. How many times you want us to repeat?
This is annexure A, Lordship. From August 2010. Total payment amount is column 3. Total deduction amount is column 4. Net amount.
Why deduction?
Deduction of HRA, etc. Your Lordship, the prior to this show cause.
Where is the salary slip for the 2018?
Lordship, we have stated and we have produced the.
This is not fair, Mr.
Lordship, the chart we have annexed.
So chart is indicating some amount. It does not say salary is how much and all.
Salary, Your Lordship, we have stated in our supplementary show cause. Prior to that, we have filed the supplementary show cause. That's why Your Lordship have adjourned this matter. That
3 years 3 years prior to filing this petition will be the what is the date?
March 2013, Your Lordship.
Can it be 2021 writ petition?
2018.
Writ petition filed in which month?
In 2021, Your Lordship.
Correct. In which month, sir? I am asking you. Well, there is a specific direction. Can't you analyze the matter and give the dates?
Lordship, sir, the chart which we have stated, which we have annexed.
I am asking you 3 years prior to means from what month?
From 2018.
Which month I am asking you? 2018 means shall I take January?
From March 2018, Your Lordship.
March 2018, what was the salary of the post attached to the post held by the petitioner. What was the post held by him?
Accountant.
Accountant.
Accountant. What? Where do you get the pay scale?
What he was paid, your lordships, your lordships will see annexure A to our supplementary show cause. It is detailed, the chart is there, and we have stated, it is there, that what was the payment, what was the DA, we have stated that the chart shows the supplementary show cause, your lordship, which was filed prior to this second supplementary show cause. It is there, so
the file
has not been done, your lordship. From March 2013, the chart shows what was the payment, what was the DA, and what was the HRA which was being deducted, the total amount, and GPF. The deduction details are there. GPF, house rent, GIS, income tax, etc. Then tax total deduction is showing.
So what is the salary? Total salary?
Net payment, your lordship, your lordship will see as column 13, your lordships. 22,773. White bill number so and so, white bank account number so and so. It was deposited in that. So this from March 13, then subsequently April 13 till May 13 with DA arrear that was enhanced, that was paid. Then again June 13, July 13. Every detail is being given. What was the payment? What was the DA? What was deducted? The GPF amount and etc. The house rent, GIS, etc. That's why your lordships have directed us on the last occasion that what was the total amount which was being paid. So the chart we have produced by your second supplementary show cause.
One thing more, lordship. Kindly see annexure 7 of my reply to the.
You can't examine one.
Lordship, I'm not requesting.
It's a complaint, sir.
My request is not to examination, lordship. Only to see the letter.
Why we should see when there is a complaint?
If they are saying compliance, lordship, then why they are issuing letters, lordship? This is also contemptuous.
Letter of what?
Letter for the recovery, lordship. Kindly see, lordship. I'm requesting the
letter of recovery.
Kindly see.
Challenge it. Recovery means.
Lordship, this is not separate matter. It arises from this.
So what is the reason for recovery?
Lordship, because petitioner has filed the writ petition for the because he not liable to pay half salary to his mother, lordship. This half petitioner appointed on the compensate ground, lordship.
Sir, up to March 2018.
Lordship,
this court is nothing to do with. After March 2018 onwards, have they paid you full salary or not?
After passing my lord's order, letters are being issued. Kindly see annexure 7, lordship, for my satisfaction.
Sir, please understand. Can I go beyond March 2018?
Lordship, they are issuing letters.
Please apprise this court, I said. Can I go beyond March 2018?
I'm not saying beyond.
Then you point out, from March 2018, there is a deduction.
Lordship, I am requesting to see the letter issued in March 2022.
Admitted for hearing.
Lordship. They have taken note of the order passed by this one.
For hearing, will hear you leisurely.
Any date may be fixed, lordship.
Serial number 4, Dolly Kumari versus the State of Judge for the Business Dr. Anjali Prasad.
May I please, in this case, I am appearing for the Bihar Police Subordinate Service Commission. Commission filed a LPA
This order will not.
Where is the stay?
My lord, that is it. I am filing this.
Stay is there?
Yes.
On what date? You give the date stay.
26/4/2023. 23.
No, my lord.
Huh? No.
Stay. Post next date of hearing of that case, lordship on 9/5.
Yes.
2023.
That has been stayed for 3 weeks, my lord.
3 weeks.
No, but stay is there?
Yes.
Lord, delay has been condoned.
After disposal of that case, mechanically. Right here, you know.
The land council for the respective party submitted that the order dated 8/12/2021 passed in CWGC 10583 of 2021. The respondents have preferred LPA and the interim order is operating. Therefore, the present contempt proceedings, present MJC stands dropped, reserving liberty to the petitioner to file a fresh MJC.
No,
the event of LPA is
one prayer, lordship. One prayer, lordship. This case may be kindly put up after the disposal of this LPA.
Here number 5 will Milad Devi versus the state of Bihar for the Krishna Sri Ajay Kumar Tiwari.
Lordship, my lord's order at page 10, your lordship, starts from page 10 of my petition.
meeting order has not been passed.
Yes, passed. Has not been passed.
That in supplementary show cause election.
What is the date I am asking you?
Your date is 21/11/22.
21?
11/22.
11/2022. Yes, take down the refusal of focus read with the order dated 21/11/2022. Is the compliance to the order dated 22/12/2021 passed in CWGC 11124 of 2021. This stands dropped. Reserving liberty to question the validity of order dated 21/11/2022.
They have passed order on wrong fact.
All right, sir, you challenge it.
I will be retired, your lordship.
So what? Just because you are retiring, can we take up this matter in contempt matter and take a decision?
They have mentioned wrong fact. That's why I am.
Correct, sir. What is the direction?
Pass a reasoned order.
If such a reasoned order is illegal, you challenge it.
But your lordship, direction contains also the date between which I was working, and that has been curtailed without any.
Sorry, sir.
Standing any reason, your lordship.
Serial number 6, Arun Kumar versus the state of Bihar for the Krishna Sri Ajay Party.
May I please, Lord, non-compliance after order date, Lord, 7/4/2021. 7/4/2022, Lord, by which not the claim of petitioner was freed. For the promotion, Lord, relevant paragraph, operative portion of the judgment, Lord. If the authority have not conducted any...
They have not conducted DPC?
My lord. No, DPC has been conducted, my lord.
On what date?
3/3, my lord. 3/3/2003, my lord. 23, my lord. After passing my lord's order, my lord, dated, my lord, 22/2022, 23, my lord. My lord's order was, my lord, 22/2023, my lord. 2 weeks time is allowed to comply with, my lord.
2023 DPC was held.
Lord.
Thereafter, what happened?
My claim was rejected for promotion to the post of Lord. On the basis of Lord backdating. 1/3/2023, Lord. ACR was manufactured or entered.
Can I go into that whether they are manufactured MJC?
No.
You state down. On 3/3/2023, DPC is stated to have been constituted in terms of orders of support, and thereafter the petitioner's grievance has been rejected. Therefore, the present MJC stands dropped, reserving liberty to the petitioner to question the validity of his rejection for promotion.
Serial number 7, Kumar versus the state of Bihar for the Krishna Sri Ajay.
The Lordship, the last direction was Lordship that the respondent should file an affidavit stating therein that they will make payment of this to this petitioner to every month, Your Lordship. Pursuant to that, this affidavit has been filed supplementary affidavit. That is third supplementary show cause, Your Lordship.
So the show cause is ready, but it's not been filed, my lord. They tried to file it yesterday, it could not get filed. I have the hard copy. Copy has been served on my friend, my lord.
You have given undertaking?
Yes, my lord. They've given the undertaking, but I must state that what they have said is, as and when the funds will be available, we'll ensure that the amount is. As and when the funds will be available, we'll ensure that the amounts are paid. And as of now, it's up.
Are you helpless in not getting the file? How can you make such statement?
No. As and when the funds will be available, they.
Correct. File is available means you don't have power to get the file. You don't have power to get the file and release the salary.
No, but that they've been, it's up to date.
Then why are you making such sanction?
It's up to date because what's mentioned in the show cause, I just stated it to my lords.
The show cause in the affidavit, the Deputy Development Commissioner has stated that as and when file of the salary is placed before him, he would release the salary.
The fund, Your Lordship.
Such a statement cannot be accepted. He being the disbursing, he being the salary disbursing authority, even if a file is not placed before him, it was bound on duty on him to get the file and disburse the salary.
Lordship, it's a fund, Lordship. It's a fund.
But Lord, I think there's some confusion. I have not stated that as and when the file will be placed before him. What I've been saying is that in the show cause, what it states is that when up-to-date payments will be made, but sometimes there is possibility of.
This is my order. Yes. With the above observation, the present contempt petition stands dropped, reserving liberty to the petitioners in the event of non-payment of any salary, salary for any payment of salary for a particular month. An interlocutory application could be filed by the petitioner in reviving today's order.
I'm obliged, my lord.
Lordship, there was a further direction to, if they fail to make payment within a certain within a stipulated time, rupees 25,000 cost will be awarded to each.
Cost has not been paid.
Cost has not been paid. It is an admitted position that the payment has not been made within a stipulated time. Thrice they have made payment, but in installment.
The Land Council for the petitioner submitted that cost portion has not been paid. In this regard, the concerned respondent is hereby directed to pay the cost within a period of 2 weeks from today, failing which the petitioner is permitted to file interlocutory application for reviving this order.
Okay. Obliged, sir. Obliged, sir. Serial number 8, Ajay Kumar Srivastava versus the State of Bihar for the petitioner Sri Shailesh Kumar Singh.
My lord's order necessary 1, page 12, my lord. And direction part was page 13, my lord. Therefore, the concerned respondent is hereby directed to decide if it is the condition by Mr. Six, read interpreted terms of past in terms of, and proceed to pass a speaking order and communicate the same to the petitioner with the document. But there no order has not communicated to me, my lord. What order is passing, my lord?
No, my lord.
The respondent has to comply.
The district statement.
This number. My lordship. This one number 3.
Number 3.
My lordship already complied. I filed a supplementary so called.
You have complied?
Yes, my lordship.
There is that order. Why don't they give it to him?
No, sir. No, my lord. Yes, my lord. Adesh ki patti sambandhit, so their order is already there.
Furnish copy to him, no?
I've got only one super, my lord. Not some disappointment.
I served the copy of just normal. But
first you serve, sir.
My lord.
First you serve a copy. Are you claiming any privilege?
No, my lord.
Then?
I have no extra copies, so that.
That is the reason you are not supplied.
No, my lord.
There is no communication, not communication, but the only order is passed.
आदेश की प्रति संबंधितों को दें.
I have not received your order, my lord, till date.
Huh?
That is my case.
No, where is the order, sir?
Here page 10 of my supplementary so called.
Show it to him.
My lordship.
Is it an order?
Page 10 of my supplementary affidavit.
Sir, it is in Hindi. I am not able to.
Sorry, sir.
Take out.
Sorry,
He has rejected that, my lord.
Sir, is it a speaking order?
No, my lord.
Yes, speaking order, my lordship.
I want, my lord,
Speaking reasoned order.
I prefer time, my lord, to examine the, my lord, order, my lord.
No question of examining.
Just yes, my lord, I have not seen the order.
Pass over. Submit 4 o'clock.
Order complied, my lord.
Order complied, my lord. I am filing supplementary.
So the respective parties submitted on instruction that orders have been complied. To that effect, filed show cause the same is taken off. Science drop.
Just one indication, my lords, if it would come in the order, my lords, there is an undertaking by him that we have, since we have filed LP also, so it would be subject to the outcome. He has given an undertaking.
You have already indicated in order that is sufficient.
Okay.
Serial number 10, Rajesh Kumar versus the State of Bihar for the Krishna Street of Sanction.
1 week time may be granted to file superheroes.
Huh?
1 week time may be granted to file superheroes.
Minister, 1 page 14 million.
Even after 1 year, why you are not passed order?
But we
The
have
order is dated 28/3/2022.
the Staff Selection Commission was to comply the order. My lord, selection was to be made by the Staff Selection Commission. I am appearing for the state, your lordship, and we have issued.
All right, we will catch all the selection authority. Why are you making submission? Who is the selecting authority?
Staff Selection Commission.
You are not representing.
No, your lordship.
Which respondent? Staff Selection Commission? Secretary, Staff Selection Commission shall be present in the court on the next date of hearing for non-compliance of the order dated 28/3/2022. Just after 2 weeks.
Serial number 11, Ranjan Prasad Samayana versus the State of Bihar for the Krishna Street of Sanction.
My lord, order has been complied with.
Monetary benefits extended?
Yes, my lord. Yes, my lord.
He's saying
My lord, he is given a false statement on the first occasion.
all it shows the show cause notice.
My lord. My lord, so cause my lord filed on 1/5/23, my lord. 1/5/2023, my lord.
1/5?
My lord, 1/5/23, my lord.
Where is the document?
Document is annexure 1, my lord.
Annexure 1?
My lord.
There is no annexure 1. Annexure A is there.
Annexure A, my lord. That is page 21, my lord.
Compliance.
My lord, it is
10 lakh.
with respect to my lord, subsistence allowance, my lord, for the period, my lord, 28/2019.
No, this is 10 lakh 8,000.
My lord.
Towards what?
Towards
No, sorry, 11 lakh 58,141.
my lord. After deducting the TDS, my lord, and the service tax, we have, my lord, 10 lakh 8,881 was paid to the petitioner, my lord.
This is what arrears of salary?
My lord, subsistence allowance for the
Subsistence allowance.
suspension period, my lord. And thereafter, my lord, provisional pension was sanctioned, my lord, 90%. That was, my lord, to make payment by annexure 2, my lord. Annexure B series at page 23, my lord, if your lordship will see. In this respect, my lord, we have already paid to petitioner, my lord, to the rupees 13 lakhs 68,457 for the period 1st April 2021 to, my lord, 31/3/2023, my lord. This is 90% provisional pension, my lord.
No, page 27.
My lord.
Where is the period mentioned?
Period was, my lord, we have given, my lord, because he retired on.
Period, where have you mentioned, sir? For which period this pension is 91st?
It was given, my lord, for the period on 31st March 2021, he retired, my lord, superannuated. So pension was fixed, my lord, from one provisional pension from 1 February, April 2021. And with
Where is that statement?
Statement, my lord, we have given, my lord, in paragraph. I'm just
not paragraph. Page 26. Where is that?
Page 27, my lord.
It is not a statement from 2021.
Here.
Huh?
First, you can see the first pension. First pension, they have paid 12 rupees in total, sir. For 20.
Huh?
First column on the page 27, sir. Cumulative pension was paid for 20 months around, sir.
What is meant by first pension?
Sir, because it was paid for 18 months. Arrear was paid in 1 person. And thereafter, it was monthly pension was paid 64 months. 64 each. Up to date pension was regularly paid, sir.
No, departmental inquiry has concluded?
Yes, sir.
What is the punishment?
100% pension withheld, my lord.
Yes. On the last occasion, there were 3 directions in the order of passed by Milords. Absolutely arbitrary Milords action and Milords in contempt of Milords order. And the principal secretary has filed the affidavit. Yes, the direction Milords will find the annexure 1, page 21 of my contempt application.
Page 25.
21. Now, page 22 is the relevant. My lords are pleased to quash the punishment order. And now the matter is remanded to the disciplinary authority inquiry authority to commence the inquiry from the defective stage and complete the same inquiry within the period of 3 months from the date of receipt in accordance with the relevant. Now, they decided they woke up from the slumber after 9 months. And they did not ascertain the defect.
They are not concerned with that.
Not on that. My humble submission is that the decision to initiate the proceedings after 9 months is in extreme contempt of the orders, because in the absence of modification by this honorable court, they could not have done it. It is in direct contempt. And they have maintaining no consistency. In one case, the similar order was passed by my lords. In one case, they have sought extension of time. I have annexed that on record also. If my lords is pleased to see my affidavit, the second, and it has not been read, by second supplementary affidavit. In this, I have referred to my lord's order, annexure 6, page 6. My lords have been pleased to pass the order on 12/12/2022. In that case, also 3 months' time was given. They could not initiate. Then they have filed an application for extension of time. That is pending. I am saying that please file extension of time. This would be in contempt of the orders of the court, because even if I...
By what date they should have completed the inquiry?
Yes, they should have completed the inquiry, my lords, by...
On 18.
They should have completed the inquiry by 15/3/2022. And surprising,
They have completed on what date?
they have completed mirrors in March 2000. I'm just giving the date, in March 2023. It is 18/4/2023. Without seeking extension of time, both of us, if I participate,
where is your explanation?
Sir, let me explain, sir. Sir, I would like to bring some facts before this court, sir. Last time he has narrated that nothing has been paid, sir. And that's why I'm standing before.
No, it's all right. There are 2 directions.
Sir.
One is for a completion of inquiry within a period of 3 months.
3 months,
Date of receipt of this order.
And that,
have you complied?
Sir, this is the letter of GAD, sir.
Huh?
No
inquiry
can be completed in such a short span of time.
Then have you made an application for extension?
The petitioner himself has sent one application before us that he is a CBI accused, and charge sheet has been filed after him, and he has filed an anticipated.
How is it relevant?
Sir, he has asked for extension of the time, sir.
Huh?
Sir, he has asked extension of
he has asked for extension of time in the inquiry procedure.
Yes, sir.
No.
Sir, please have a look on the annexure, sir. I'm sorry. Page number 33, sir.
33 of what?
This supplementary SOCO.
Sir, supplementary SOCO, sir.
It is dated 1/5, my lord. 1/5, my lord.
What is this 33?
That he has filed an anticipatory bail before this court, sir, and he is not in position to appear before this inquiry officer, sir.
No, was he under custody?
No. He was, I can't say, but he may be absconded.
No, was he under custody?
No, my lord.
No, if he fails to appear, you have the opportunity of passing expiry order.
No, that's why, sir, we have to give the opportunity, sir. Last time you have questioned.
No, correct. One can understand. 15 days, 10 days, all right. But not 1 year.
But different stages are there. Last time you have.
You have taken 1 year time.
You have only questioned our order because we have not followed the procedure. Last time, sir, it is.
Sir, what is the direction, mister?
Sir, it is.
What is the direction?
It was to conclude the inquiry as per law.
Within 3 months.
Law also, sir.
Within all right, as per law. Which is the law says that beyond 3 months?
Sir, here is the law, sir.
Huh? Then where is the application for extension of time? In terms of this law, you provide us.
Because, sir, he has not cooperated. The petitioner should have cooperated in this.
You had a power of party.
Sir, that's why finally we have ordered like this only, sir. Sir, finally we have ordered ex parte only, sir.
Sorry, sir. I'm going to impose cost.
Lordship, before my lord passes, this is again an incorrect statement being made by the opposite party. If my lord says, please to see annexure 3, page 30. Because we cannot, this is a contempt annexure 3, page 30. Annexure 3, page 30 of my contempt application. On 19/12/2020, immediately the moment I received this decision of the government, I have written letter to the inquiry officer and everyone that see this is.
I'm not concerned with that.
No, but I have said that it is.
I am not concerned. It is bound and duty for them to complete the inquiry within 3 months.
And in other cases, they are seeking.
There is an option of making an application for extension of time.
In other cases, they are making it. In my case, they are not making it.
Take down.
My lord will file, my lord, for extension, my lord, because the rule of the General Administration Department of the says that 12 months, my lord.
While enclosing the rule,
my lord,
you should have filed an application for extension of time. Where is the application?
My lord, I'll file, my lord.
You file after a lapse of time.
My lord, it is my lord.
I will record that also. Yes, take down.
Because my
present NJC is
reason, my lord, is
for non-compliance of the order dated 14
on the law, my lord.
Passing sheet of the GC 2695 of 2020. In para 4, the following direction was given. Sir. The above direction was required to be complied before 18/4/2023. Sorry, before 15/3/2022, or from the date of receipt of this order, 3 months. Assuming that the respondents are in receipt of the present order in the first week of April 2022. Sorry. First week of January 2022. Even then, they should have complied.
Let's see the order has been complied with.
Whereas the order has been complied on 18/4/2022. Next file.
My lord, we have already tendered, my lord, unconditional and unqualified apology.
The order could not be complied within the time limit stipulated in the light of the government circular or office order, which permits 12 months time to complete the inquiry. Such a statement cannot be accepted. It is nothing but circumventing the orders of this court dated 14/12/2021. So, assuming that the intention of the respondent is to seek extension of time, as there is the time limit stipulated by this court is not feasible for them to conclude the inquiry. In such an event, there should have been an interlocutory application for extension of time before expiry of the time limit stipulated the order dated 14/12/2021. With the print date, there is no application for extension of time, or even before 18/4/2023, the date on which orders have been complied, there were no application for extension of time.
Submission, my lord.
To stop. In the light of these facts and circumstances, it is a clear case of contempt. Therefore, the contempt petition stands dropped. NJC so and so dropped, subject to payment of cost of rupees 25,000. Call shall be remitted in the High Court Legal Service Authority within a period of 4 weeks. For compliance, release this matter after 4 weeks.
Sir, in this case, because the petitioner has not cooperated, sir, I would like to request to review this cost. But
at this stage, Mr. So and so officer submitted that the petitioner has not cooperated in the inquiry. To stop. If the petitioner has not cooperated in the inquiry, in that event, the respondent officer's hand was strengthened by this court order, specifically that the inquiry is required to be concluded within a period of 3 months. Therefore, he should have resorted for ex parte inquiry if in the event of non-cooperation from the petitioner.
We have already tendered, my lord, unconditional and tendered unconditional unqualified apology, my lord.
For what purpose?
For the purpose, my lord, that
Sir, if it is, I can understand 15 days, 1 month, not 1 year.
main order we have complied, we have paid the amount, my lord, 23 lakhs.
Mr. Senior Counsel.
My lord, on 20.
Please listen, Mr. Senior Counsel. In each and every case, the party has to file a NJC for implementation. Why can't you suo moto implement?
We have taken, my lord, first, my lord, opinion from the my lord, legal department. My lord. That's why, my lord, it is, my lord. So
yes, sir.
Time, my lord, that my lord may not settle with the.
Sorry, sir.
Your Lordship. G. Jhatka Singh versus the Union of India for the traditional free action.
Your order has complied with it.
Your Lordship, partly complied. Then I have joined Your Lordship.
I have joined the service, my lord.
What about monetary benefits?
After regular pay, it will be paid soon, my lord. After regular
pay. It has not been complied. Order is complied in part. Namely, so far as the reinstatement is concerned. However, monetary benefits have not been settled. Therefore, the concerned respondent is hereby directed to settle monetary benefits within a period of 2 weeks from today. Accordingly, the present contempt petition stands dropped. In the event of non-payment of monetary benefits, the petitioner is at liberty to make to file interlocutory application for revival of the present order.
This is restoration application, my lord. Restoration application dismissed for default on 28/3/2023. On that day, my lord, I personally requested orally, and your lordship directed me to file a petition. Then it will be restored.
Taken heard NJC so and so for recalling the order dated 28/3/2023, passing CWC for the reasons stated in the application and affidavit. NJC stands alone. Order dated 28/3/2023, passing CWC so and so stands recalled. CWJC 4881 of 2012 stands restored. Registry is hereby directed to this CWJC 4881 before the appropriate roster bench. Subject to payment of cost of rupees 2,000, cost shall be remitted in the High Court Legal Service Authority within a period of 2 weeks.
My lord, he is very poor person. My lord,
You pay from your pocket. Why the litigant has to pay? Because of your fault.
फॉल्ट हुजूर नहीं था. असल में कोर्ट में दिखाया नहीं. हुजूर के सामने हम उस दिन मेंशन भी किए. तो हुजूर ने कहा कि नहीं
पेमेंट करो.
500 कर दिया जाए.
No. Don't bargain. Don't underestimate this Pattai code. This is a constitutional code.
Serial number 14, Kumar Sanjay versus the State of Bihar for the petitioner issue to Jhatka.
My lord, this is restoration matter, my lord. This is a restoration matter, my lord. By order dated 22nd of September 2022.
Same order. 22/9/2022 order. Passed in CWJC 19757 of 2010.
Apply.
Cost 2000.
My lord, it may be reduced, my lord.
Huh?
Maybe it was because it was the fault of, not a fault of the petitioner.
No exemption, no discrimination.
Petitioner was at no fault on.
No discrimination, sir.
Maybe 1,000, my lord.
Huh? Alright, you pay from your pocket, nothing will happen. You are expecting only incoming. It must outgoing also.
My lord, this is a fault.
The heading to be mentioned, serial number 15, Prabhu Dayal versus the State of Bihar for the petitioner Vinod Kumar.
Lord, we have filed an IA application for fixing early date of hearing.
Again, for?
Early date of hearing, my lords. Lord, the petitioner has 14.
Alright, and the application stands for the reason stated in the application and affidavit. This matter after vacation. June last week.
Obliged.
Serial number 16, Jai Shankar Singh versus the State of Bihar for the petitioner Vinod Kumar.
Pass on the date and sequence. Dates and events.
What is today? It has been listed for what?
It was fixed for today, Your Lordships. It has been adjourned for today. On the last date, the State Council were asked to produce the records.
Records, Your Lordship.
There is a district magistrate. District magistrate was required to comply.
It has been said. Record has been Your Lordship.
Record has been?
Your Lordship.
You are in receipt of record.
Please, Your Lordship. Annexure 1 is the order passed by the district magistrate, Your Lordship, by which the petitioner has been dismissed from service.
By?
Your Lordships, by Annexure 1 at page 36, the petitioner has been dismissed from service by order dated 1st of March 2014, Your Lordship. The petitioner, Your Lordships, was a revenue kamchari, revenue clerk, Your Lordships, and he was posted at Patna. When he was suspended, Your Lordships, on 6th of December 2012, and subsequently the said suspension was revoked, and it was decided to initiate a departmental proceeding against the petitioner, and a charge memo dated 10th of January 2013 was framed, Your Lordship.
What is the date?
10th of January 2013, Your Lordship. The charge memo is at Annexure 4. Your Lordship, the charge is, Your Lordship, that the petitioner, while being posted as a revenue kamchari, he had submitted a report to the effect that the name mentioned in the record of rights, the name has been recommended for mutation of the land in the name of the person mentioned in the record of rights. But in the record of rights, it is being mentioned as a dakhalkar. The name is mentioned in the record of rights, but so far as the body who would be taking the revenue, the same is being mentioned as PWD, Public Works Department. In the record of rights, two names are mentioned, Dakhalkar Raiyat and Dakhalkar.
What is meant by Dakhalkar?
Dakhalkar record, it is being said, Your Lordship, that the lease is being given in favor of a person by a particular department, Your Lordship, Public Works Department.
Land is PWD.
Land is Your Lordship, the land is being mentioned as.
Who is the owner of the land?
The owner, since your lordships, I have stated, it is PWD, your lordships.
That has been given in lease to which? To who?
To your lordships, Gulab Khan in the year 1930.
A private person.
He is a private person. He is a private person. In 1933 itself, as per the municipal survey Khatiyar prepared in the year 1933 itself, the name of the Rayat is there. Your lordships, subsequently, the Jamindari has been vested in 1956 and all the revenues has to be collected by the state government, your lordships. And therefore, only that Gulab Khan, the ancestors of Gulab Khan, had given an application for mutation of the land, enclosing the municipal receipt, your lordships, the electricity bill, as well as the land possession certificate. Everything was given by that person. And subsequently, a report was submitted, your lordships, by this.
He is a leaseholder.
He is a leaseholder.
Just because he furnishes electricity bill and other things,
because he was
going to change the name of the.
Your lordships, he was in possession of the land.
So what? Where is the scheme of the state government? If a person is in possession, that land is required to be stands in his name.
Your lordships. Therefore, Annexure 4, your lordships will kindly see for a moment Annexure 4 at page 49, which is the charge memo. The charge memo, your lordship, does not bear the imputation. The imputation, if your lordship will kindly see, neither the name of the witness is being mentioned, no witness is being examined, neither any document has been exhibited, your lordship, and nor has been proved by in the departmental proceeding. Only on the vague allegation, your lordship, of the charge.
We will set aside and remand the matter.
Lordship, on the basis of the documents, on the basis of the fact that he has reported.
The petitioner is a government servant.
Lordship.
CCA rules are applicable.
Lordship.
So as there is a compliance to Rule 70.
Lordship. In that case, may be demanded, Lordship.
So you admit there is a non-compliance. You state down in the instant petition, petitioner has prayed for the following relief. The petitioner, while working as a revenue karmachari, was subjected to was placed in the suspension on 6/12/2012. Later on, he was subjected to disciplinary proceedings, framing article of charges on 10/1/2013. He had submitted his reply to the charge memo denying the alleged charges to stop. Still not satisfied by the disciplinary authority, disciplinary authority proceeded to hold an inquiry. The inquiring officer submitted a report on 10/6/2013 to the extent that charges leveled against the petitioner were proved. Based on on receipt of inquiring officer's report, the disciplinary authority proceeded to issue a second show cause notice on 4/11/2013, and thereafter proceeded to impose the penalty of dismissal from service on 1/3/2014. So the petitioner, feeling aggrieved by the order of dismissal, proceeded to file appeal before the appellate authority, and it was rejected on 19/1/2016. Hence, the present petition. Next, counsel for the petitioner submitted that charge memo dated 10/1/2013 and further proceedings are not in accordance with Rule 17 of so and so Rules 2005. Next, counsel for the respondent has not disputed that there is a compliance to Rule 17 of CCA Rules 2005. The right of these legal lacuna, the petitioner has made out a prima facie case accordingly. Dismissal order dated 1/3/2014 and rejection of appeal dated 19/1/2016 stands set aside. What is the age of the petitioner?
Your lordship, the petitioner, your lordship, is a handicapped person, your lordship. And
I am asking you,
your lordship, 52, your lordship. At present, 52 years, your lordship.
Reserving liberty to the respondent / disciplinary authority to initiate fresh inquiry and conclude the inquiry within a period of 6 months from the date of receipt of this order. In the meanwhile, disciplinary authority is hereby directed to take a decision as to whether petitioner could be placed under suspension or he shall be taken back to duty or not. In the light of Apex Court decision in the case of the MDECIL read with Coal India so and so. Chief Authority hereby directed to pass a sweeping order as to how to regulate the intervening period from the date of dismissal till passing the fresh order in the disciplinary proceedings. The speaking order shall be passed within a period of 2 months from the date of passing of a fresh order in a departmental inquiry. With the above observation, repetition stands followed.
Serial number 17, Bhola Thakur versus the State of Bihar for the prisoners to C.R. Rampande.
Pray for pass over, my lord, because the file is not between, but the order is complied with. My friend says कि इनको copy नहीं मिला है, therefore I am praying for pass over. Order is complied. He is 18 now.
Complied in his favor or what?
No, against him.
What is the date of the compliance order?
2/5/22, madam.
2/5? Today?
No, 2/5/22, madam.
22?
Yes, madam.
Then contempt is filed on what date?
But I don't have the brief, madam, therefore I can't assist properly, madam. Maybe past
25/4.
But physically you are present here.
Madam.
25/4/2022. Contempt application was filed.
And consequently, the respondent on instruction submitted that the order of this court dated 21/12/2021 passed in CWJC 19731 of 2021 is complied while passing order on 2/5/2022. The NJC stands dropped, reserving liberty to the petitioner to invoke appropriate remedy if he is still aggrieved by the decision of the respondent dated 2/5/2022.
Serial number 18, Kiran Chaudhary versus the State of Bihar for the prisoners to C.R. Rampande.
My lord. My lord, a SOCOS has been filed on behalf of the university. And my lord, kindly see lecture A. The last portion.
First of all, where is the order?
My lord, order of my lords, that is in lecture 1.
Page?
My lord, page 11.
Speaking order has been passed or not?
My lord, that has been passed on 21/11/2022. Last portion, my lord, may kindly see in lecture A of SOCOS at page 9. In view of above, it is opined that.
Where is that? In view of the above means?
My lord, that is in lecture A of SOCOS 5.
Challenges, yes.
No, my lord, it has been mentioned that in view of above, it is opined that the claim of the petitioner regarding so and so regarding grant of SCP is rejected, being not maintainable. However, the petitioner is entitled to benefit of one MSCP, which shall be payable to him within a period of 8 weeks from the date of order. The representation of so and so is disposed of.
Yes.
My lord, that letter has been issued on 21/11/2022, but till date, MSCP benefit of MSCP has not been given. My lord, the authority has itself admitted that the petitioner is entitled to get the benefit of MSCP, though my lord, the benefit of SCP has been denied. But
that does not amount to contempt. Sorry, the direction is only for compliance. That's all. You have rightly or wrongly, you have passed in order.
No, my lord, I am not on that one. Because my lord, the authority has itself the petitioner.
Sorry, it does not amount to contempt. We will make only an observation to settle at the earliest. That's all. If they don't.
MSCP का हुजूर benefit.
NJC, the petitioner has alleged that there is a non-compliance to the orders of this court insofar as consideration of his grievance relating to ACP/MACP Full stop. Respondent Baba Saheb Bhimrao Ambedkar Bihar University passed an order on 21/11/2022 to the extent that the petitioner is not entitled to DCP. On the other hand, they have admitted that the petitioner is entitled to MACP benefit and it would be settled within a period of 8 weeks. Full stop. It is submitted by the petitioner that it has not been settled. Therefore, registrar Respondent University is hereby directed to obey your own order dated 21/11/2022 within a period of 4 weeks from today.
Compliance to the
4 weeks from today. Including monetary benefits, including any areas of payment. In the event of non-compliance by the registrar, Respondent University, petitioner is at liberty to file interlocutory application to recall the present order. Stands dropped.
Not complied, my lord. They have taken a stand that since there is ban of the state government on promotions or any consulting of the DPC committee, therefore the case of petitioner has not been considered, and although they have issued office order, that is Annex 3 series starting from page 22, my lord, wherein they have stated that the cases of petitioner would be considered after the ban is my lord.
Challenge it independent.
But my lord, they were required.
What is the direction?
My submission is that they are
Sir, what is the direction?
Suitable order, my lord. Therefore,
suitable order has been passed. Stating that
lawful order is not there. My submission is that my lord,
it is not lawful.
On the same time, they are continuously giving promotions to others. I have annexed, my lord. That is annexed.
Sir, you
my lord. Sorry.
Challenge the promotion order of such of those discriminated persons.
Others annexed.
Sir, you also, there is a Supreme Court decision. During pendency of certain litigations, they have passed an interim order that the pendency of the litigation before the Supreme Court would not come in the way of giving promotion. Such a promotion should be conditional one, subject to result of the Supreme Court decision. You produce all those things and apprise them. Yes, take off. Counsel for
Lord, may direct them.
Respondent submitted that.
My lord, my
there is a compliance to the order.
That order, my lord.
11/1/2022.
And they have not timely. They have not timely complied, my lord. 3 months time. 3 months time was fixed, my lord.
Appropriate authority
issued order, and they have asked.
Scene number 20, Vaishnav Prasad Singh versus the State of Bihar for the petitioner Sanjay Kumar.
Lordship, we have filed our so-called lordship. All the petitioners have been taken back into from the date of dismissal, and the suspension allowance already been given. Lordship, order has been complied with.
A copy of the order may be.
What is the date of order?
Date of order, Lordship, 2/10/2022. 12/10/2022. 2022, Lordship. Annexer D at page 25.
And counsel for the respondent pointed out Annexer E.
D, Lordship. D at page 25.
Annexer D. But because the compliance on this court order on 7/10/2022. The rate of facts and circumstances stands dropped. The petitioner that if he is still aggrieved, he is permitted to challenge the action of the respondent in accordance with law.
Maybe give me a copy of the so-called
Yes,
policy.
that I can give you. Hum dे देंगे copy दे.
Sir, State Council, what is wrong with your office? Most of the cases, you people don't serve a copy.
It has,
First, you serve a copy.
it has been served on 8/12/2022 as
Under whose signature? Has he signed it? Has he put his signature?
record will show lordship. Record will show.
Good.
Yes.
Show it to your brother.
Number 21, Kumar versus the state of Bihar for the discussion CBG field.
It has been served.
Junior has accepted. Junior.
Why not?
Your Lordship, the order has been complied with. Your Lordship. The appeal has been disposed of, Your Lordship, by the district magistrate. Your Lordship.
On what day?
On 21/2023, Your Lordship.
21?
2023, Your Lordship.
No, which month? 21? 2?
21, month 1.
January. None appears for the petitioner. None counsel for the respondent. Submitted that on 20th January 2023, order has been complied. Accordingly, the indices is not.
Number 22, Jhatka versus the state of Bihar for the prisoners with
The order has been complied with.
Lordship, there is one deal has been decided to withdraw the case.
Sometimes dismissed as not in view of a later development.
Number 23, Ms. Valeen Soni versus the state of Bihar for the prisoners with
Lordship, Bhard order number 5, dated 12/4/2023, notice has been issued, Lordship, that has been complied, Lordship. Lordship, in this case, alleged allegation against the petitioner to demand dowry rupees 1 lakh and motorcycle, Lordship. Annexure to as paid 13, Lordship. Only general and ominous allegation, Lordship. And Lordship, Bhard order dated.
How the anticipated bill is maintainable? When did you file?
Lordship, Bhard order dated 3/11/2021. Passed in criminal miscellaneous number 80242 of 2019. Lordship was pleased.
Are you absconder?
No, Lordship.
Then how anticipated bill could be maintainable even after a lapse of 5 months? That means there is no threat. We'll drop the contempt procedure. We'll drop the anticipated bill petition. Stating that there is no threat. Threat of arrest must be there, no?
Lordship, first of all, it has been filed before session court, where mediation has been done, but it was failed, Lordship. Then, before Honorable Patna High Court, Bhard Lordship order, direction was to expedite the matter in the event of any such application or memorandum is presented to Lordship at page 10, Lordship. Page 10, Lordship. Annexure 1 at page 10, Lordship. Operative para, Lordship, last. Further, at this juncture, learned counsel submitted that the parties are likely to settle the dispute amicably before the district medicine center. As such, the parties are at liberty to approach so Lordship. Lordship, compliance to that order, petitioner remained present on each and every date, Lordship, fixed, but OP number 2 did not present there. Therefore, mediation proceedings would not start, Lordship. It has also come by order dated 10/8/2022 at page 16, Lordship. Kindly may be seen, Lordship. OP number 2.
Go and make a regular bail application, sir. We can't entertain anticipated bail 2019 to 2023.
Lordship,
There is no threat.
Lordship, sequence kindly may be seen, Lordship.
All right, where is threat? That threat of arrest.
Non-billable.
Show the material.
Lordship, after taking cognizance.
Sir Counsel, please show us where is the threat of arrest.
Lordship, objection.
At what point of time anticipatory bail could be entertained? Could be placed a threat.
Lordship, kindly, I want to place my submission, please. Maybe heard, Lordship. Lordship, the object of section 438 is to prevent undue harassment of accused persons by pre-trial arrest and detention. Lordship, police searching the accused.
Therefore, that is the reason I asked you earlier, are you absconder? You said no. For the last 2019 to this day, you are absconding. You are hiding elsewhere.
In mediation, there is no coercive.
Not mediation. Therefore, there is no threat from the police.
Lordship, first of all,
you want to withdraw? You want to withdraw? Shall I dismiss? Go and better invoke appropriate remedy of seeking regular bail.
Lordship, kindly, maybe.
I'll make an observation at the best. You go and surrender today, and tomorrow you make a regular bail application, and I will direct the concerned judicial officer to consider your regular bail application within 2 days.
Lordship.
If you want such a direction, I will give. Otherwise, simply I reject.
Same day, Lordship.
No question of same day. He must have been petitioner. For 2019 to this day, he is absconded.
With liberty.
This is second round litigation by the petitioner insofar as seeking anticipatory bail arising out of complaint number 232 of 2017 for the alleged offences punishable under section 323, 341, 498A and 504 of IPC and section 3/4 of the Dowry Prohibition Act, which is pending consideration on the file of Subdivisional Judicial Magistrate Vikramanganj, Rohtas at Sasaram. Perusal of the record, it is evident that complaint relates back to of the year 2017. Anticipatory bail is filed in the year 2019. And it was disposed on 3/11/2021. Before that, criminal proceedings number 80242/2019 was disposed on 3/11/2021. Thereafter, the present criminal miscellaneous 1697 of 2023 has been filed. These dates and events reveal that there is no threat of arrest so as to entertain anticipatory bail in a complaint case of the year 2017 in the year 2023. Accordingly, the present criminal miscellaneous 1697 of 2023 stands rejected. However, the petitioner is at liberty to surrender before the jurisdictional court and make a necessary regular bail application. If such a surrender and regular bail application is submitted by the petitioner, the competent authority / court is hereby requested to decide the petitioner's regular bail application within a day or two, within a day Sir, with the above observation, the criminal miscellaneous so and so stands dismissed.
In the heading for orders of petition, style of serial number 24, Dr. Rakesh Ranjan versus the State of Bihar for the petitioner fees received.
Order passed on the 17th December 2021. More than 1 year has been passed, and Lordship will issue RN. Then, Lord, I know the fate of my case. He rejected my claim, Lordship. By tomorrow, within 2 days.
Where is my order?
Order at Lordship, page 25 of the brief, Lordship. Operative part at Lordship, page 28. More than 1 delay has not been explained. Within 2 months, 29 Lordship. When contempt petition is filed, then you will be asked to personal appearance, then issue warrant, then you rejected my claim. 1 year delay has not been.
Have they complied?
Just rejected my claim. That's Lordship. Today, suppose I filed, he files a reject order, Lordship. He rejected my claim.
What is the reason order date?
Date is 34/23.
34/23. In your focus, have you explained the delay?
No, my lord.
This is Advocate General. This is not isolated case. In each and every case, just about half an hour back, there was a direction to pass a speaking order or something to complete the inquiry within a period of 3 months. They have taken 1 year. No application for extension of time. At least if there is a difficulty in implementing the orders of this court, before lapse of a particular date, you must make an application and seek an extension of time. This court is not, this court will not refuse to grant extension of time. But you can't sleep over the matter. Time and again we are repeating the same thing, but no response from the state. The reasons have not been assigned. Delay.
Delay has not been explained in that.
Then why we should I should not impose cost?
My lord, since issue warrant on 19/4/2023, thereafter intentionally rejected my claim.
Warrant was issued.
Lordship.
On what date?
19/4/2023. Warrant issue, I'm saying my client, I know fate of my case also. Maybe it must be rejected.
See.
No, my lord, warrant was issued in the circumstances that he was out of Bihar in respect of.
Even though that is the case. Even in that case also, where is the application for dispensation of his personal appearance? Such application is required to be filed in advance. And such application has been filed by his colleague.
My lord.
How can he authorize? Where is the authorization?
He was, the colleague was, my lord, in charge of that department on that very day, in his absence.
Correct. In contempt matter, a party is required to be filed. Party has to, not in charge officer.
The concerned officer, my lord, on
petition. Sorry, the present NJC is for non-compliance of the order dated 17/12/2021. Direction was required to be complied in passing a speaking order within a period of 2 months. However, the concerned respondent has taken sweet time of more than more than 1 year in complying the order. The same was taken note of personal appearance of the concerned officer was ordered. So he was not present on the date fixed. In the result, bailable warrant was issued. So today, the concerned officer is present in the court. So picking up complaints of the order dated complaints order dated 30th April 2023. Contempt proceedings stand dropped. However, this court has come across in number of cases, especially in contempt matters, there is a non-compliance for years together. In other words, state government is not respecting the orders of this court. So if they have any difficulties in implementation of the court order, they have every option of approaching next higher court or seeking extension of time for compliance. All these available remedy has not been taken note of. On the other hand, keep on committing the contempt of court, which has resulted in issuance of which has resulted in personal appearance, bailable warrant, etc. The state must take note of these events for the purpose of other identical matters of contempt, so as to avoid embarrassing situations in the court on behalf of the state. To stop the above the contempt petition stands dropped. Bailable warrant issue stands dropped while discharging the bailable warrant.
Liberty may be given to challenge this.
The petitioner is at liberty to question the validity of the order dated 30th April 2023 in accordance with law.
Serial number 25 is dropped. Serial number 26, Vanita Kumari versus Vanita Kumari for the petitioners, the Jhatka Jha.
My Lord, the lordship's order is at page 6, wherein your lordships have directed to in the prayer of the petitioner was to payment for from 16/8/2018 till date, and the next is, my Lord, therefore the concerned respondent is hereby directed to redress the grievances of the petitioner. Speaking order passed, but he has not stated about the payment of the salary of the petitioner, my Lord. He has dismissed the petitioner, my Lord. He has not even
salary.
Yes.
He has not. He has admitted that the petitioner was appointed.
Correct, sir. Salary has been denied. Then where is the question of granting monetary benefits? You challenge it. What is the date of the order?
19
month
9/2022.
Lord, may kindly see.
For the respondent.
Lord, may kindly see the order, my Lord.
The order dated 19 order dated 7/2/2022, past 645 of 2021 has been complied in passing a speaking order on 19/9/2022. So accordingly, the present NJC stands stop reserving liberty to the petitioner to assign the order dated 19/9/2022 in accordance with law. See the direction, sir.
This petitioner came before the lordship for the payment of his salary, her salary, my Lord. That has not been complied, my Lord, because
No, that has not that has been. You have made an application for payment of salary. I have directed them to consider your grievance and pass speaking order. Now they are saying they have passed a speaking order.
One thing, your lordships have already also directed that the passing as if the petitioner is otherwise eligible.
If he is otherwise eligible, that means what condition? If you are eligible, then only monetary benefits.
And they have
not say that you are not eligible. You have to establish before the in challenging that order, stating that I am eligible.
But they had not said about the payment of the salary in this in that order, my lord.
Then what they have stated?
They have simply stated, my lord,
that you are not eligible for what?
Because the state government has stated that the सूचना का दिनांक निर्गत होने के बीच
his appointment is illegal.
His appointment is illegal.
Legal, yes.
Have you terminated his service?
He has been terminated.
No, but you have to pass orders on salary.
Certificate on which he was appointed, that was.
Correct. Has he worked or not? This court, Mr. State Respondent,
yes, sir.
This court has directed you to pass a suitable order insofar as arrears of salary is concerned. You are saying that his appointment is illegal.
He was not appointed. He was not appointed.
Or may kindly see his order, my lord.
He was not appointed.
He himself stated, my lord, in 3, Vinita Kumari ka chayan sevika.
Let it be passed over few cases. I'm just examining.
Strike off the previous sentence. Then counsel for the state respondent is hereby directed to file a specific get instruction as to rejection of petitioner claim is with reference to salary or his appointment. Land counsel for the petitioner pointed out that rejection is with reference to his initial appointment is illegal. That is nothing to do with the relief sought in the present petition, in the original writ petition. This matter next week.
Obliged.
Serial number 27, Paras Nandasan versus Mr. Sanjay Kumar for the business reproduction.
My lord, second so-called received just a minute, my lord. Oh, kindly pass over, my lord.
Supplementary so-called, my lords. I have filed on, it was filed on 1/5/2000.
You complied?
My lords, the order has been complied.
In his favor or against?
Lords, no, my lords. The claim for the SCP has been rejected.
Rejected.
Lords.
On what?
It is 1/4/2023.
1/4/2023. Take down the instant petitioner as alleged that there is a non-compliance to the order dated 4/2/2022 passed in serial with 5852 of 2021. The respondent counsel submitted that on 4/1/2026 an order has been passed to the extent that the petitioners are not entitled to ACP benefit and consequential benefits. In this regard, the petitioner is at liberty to assign the order dated 1/4/2023 before appropriate forum. Accordingly, NJC stands dropped.
My lord, annexure 8 of the main petition has many petitioners receive a SCP or RSP, my lord.
You are a Jilla Panchayat employee?
Yes, my lord.
There is in the ACP scheme.
Then ACP or MSC.
Sir, in the ACP scheme.
Yes, my lord.
If I am correct,
order dated
In the ACP scheme, if I am correct,
Yes, sir.
sub rule 1 of rule 2 prohibits extension of ACP to the panchayat employees. Find out.
Honorable Justice शिवाजी पांडे का ऑर्डर 18/1/2018 का इसमें लगा हुआ 52 पेज नंबर.
My order is only for consideration of your claim for ACP benefits. Rightly or wrongly, they have rejected. You have a remedy of filing fresh writ petition. Any more advice you want?
Serial number 28 is withdrawn. Serial number 29, Ravi Kumar Ram versus the State of Bihar for the Krishna Sri Arun Kumar from Bihar.
Order has been complied with.
No, not complied. Page 10 of the law.
Where is the direction?
Direction of page 10, 7th line from bottom.
Huh?
Page 10 of the in this. On receipt of the petitioner's explanation, the concerned respondent appointing officer is hereby directed to proceed in accordance with law after due consideration of each the contention of, to be raised by the petitioner in his explanation within a period of so and so. They say संतोषजनक नहीं है only. They use the word by rejecting my claim that it संतोषजनक नहीं है.
What is meant by that?
My lord,
is the what is
notice has been so-called note.
Where is the Shokas notice?
Annexary.
Where is his reply?
Reply is, my lord. Of contempt, my lord.
I have annexed the reply. Page
3, my lord.
Huh?
Page 13, my lord.
Page 13.
13 of what?
MJC, my lord.
Milord, I am giving one example. Page 18 of the so-called may be seen.
You produce a translated version of Annexure 13. Page Annexure P3 and Annexure B. I will examine. The Land Council for the petitioner is hereby directed to furnish a translated English translation of Annexure P3 and Annexure B, so as to examine whether the petitioner or respondents have committed contempt or not.
Serial number 30, Dr. Kamil Prasad Singh versus the State of Bihar for the Krishna Sri Pawan Kumar.
Thank you, Lordship. Wide order dated 19. This is second contempt application, my lord. On the day the first contempt was disposed of.
Where is my direction?
My annexure 1.
At page 12 of the page 12 of the contempt petition.
Page 12, my lord.
The relevant portion I will find.
You also produced. Along with your counter, you have produced.
So far as this contempt petition is concerned, it is not material at all. Because
now, let us see first what is the direction.
My lord, the direction is first this penalty order was set aside with a direction.
Operative part at page 15.
Should I read, my lord?
On ad hoc basis, have you promoted him?
Promotion.
Where is that order? Ad hoc promotion.
Because my lord will find that at annexure 3 at page 17.
What is the date of ad hoc promotion?
A letter causing state on instruction submitted that petitioner have been promoted to the post of additional chief medical officer during the course of the day. In the light of such submission, present content petition posting is dropped.
So where is the ad hoc promotion order?
But, because from it is evident from my lord's order that the promotion has been given.
Where is that order? How many times you want me to repeat the same thing? Can't you understand or what?
But that order is concerned that order is not given.
Then I will issue bailable warrant.
Because it is the admitted position that he has already.
They are not on merits. I want only two things: to comply my order, or go and get a LP stay this order.
So far as my order is concerned, it has already been complied with.
Show us the order. I am asking you, show the.
He is also admitting that yes.
Sir, you are the authority. Compliance. Where is the order?
But for second, I may be asking, Lord. It is also admitted that yes, promotion has been given, my Lord.
All right. You show us the order. Order dated 19/5/2022 stated you have not been complied in promoting the petitioner to the post of additional chief medical officer on ad hoc basis. Respondents are not in a position to apprise this court whether petitioner has been promoted to the post of additional chief medical officer on ad hoc basis or not. The same is not placed it on record before the next date of hearing. Adverse order would be passed against the concerned official. This matter next week.
His personal appearance in serial 34. Serial number 34, Dinesh Pratap Singh and others versus the State of Bihar and others for the petitioner Sri Vishwadeep Kumar Mishra.
Kindly, Lordship's earlier order dated 19/4/2023, Lordship.
In compliance with the Lordship's order, I am filing Lordship a supplementary affidavit bringing on record, Lords, the chart whereby, Lords, the vacancies have been put out from the office records and the same have been incorporated herewise.
Take page 11. Page 11. Item number 1, merit the notification 27/5/2004.
Notified by department memo number such and such 27/5/2004. Next page.
How many persons have been promoted by this?
No, these are these lists of vacancies, not promotion.
Then where are the promotion notification?
Promotion notification is annexure 6, my lords.
Year-wise?
No, not year-wise, because year-wise promotions could not be given since 2003.
All right. At a time you are promoted. Such are those 52 vacancies.
Yes.
At a time. By which?
31. We have given 31. 31. We have
31. Where is that notification?
That notification is annexure 6 to the writ application. Page, my lords, is 119.
119.
119
119 of my lords CWJC 6773. वही है ना?
Annexure
6773. Annexure 6.
Notification number 119. Lordship. Impugned order.
Here, my lords, 31 persons have been granted promotion.
Promotion prospective or retrospective?
No, it has been made prospective, but subsequently it was made in 2010, but by subsequent order it has been shifted back to 2008.
2008?
Yes, from the date.
No, all the 31 persons have been granted promotion to the post of junior engineer with effect from.
They have been all these 31 persons were serving as junior engineers, and they were entitled to get promotion to the post of assistant engineer
against my lords 10% AMI.
All right. The assistant engineer promotion given on 1/4/2010 is traced back. Thereafter, it was rectified that they are entitled to from 2008. What is the date of 2008?
2008, my lords, is that is, my lords, that your lordships is annexure B to the affidavit filed today. Page, my lords, 24. चौबीस को किया है 24. We have shifted that.
Twenty-two 10/2000. What is the year? Annexure B.
Annexure B is my lords 2/10/2000.
No, 22/10.
22/18.
18.
My lords.
Column number 4 is relating to senior.
Column number?
Column number 4.
Lordship.
Yes.
Seniority.
The year 2009.
Position of senior.
Alright, what is the ranking of the petitioner?
Petitioner's ranking.
Lordship, petitioner's ranking is your lordship. According to
but before my lords may say,
petitioner number 1. Lordship.
Before my learned friend lords submits, there are two rankings, lords, which are given. One, there are two numbers, two positions. One.
No, sir, one second. For the purpose of this promotion in the year 2010, which seniority list you have operated?
This was operated on the basis of seniority, on the basis of persons who were qualified to get promotion.
Which seniority list of the feeder cadre?
That is the seniority list we have, my lords. That is annexure. Well, that is annexure, my lords. 3, page 21.
What is it? 24/9/2009.
24/9/2009. This was the seniority list which was prepared with respect to persons who became eligible for the purposes of.
No. Not eligible list. I am asking you, where is the seniority list of
seniority list on the basis of persons who are eligible? Other seniority has got no meaning.
No, you are not prepared seniority list? You are not prepared the seniority list of junior engineer?
Yes, junior senior.
Where is that junior engineer? That list is required to be operated further. You may be taken certain material from that list for preparation of page 21. Eligibility list. This is eligibility list, not seniority list. Lot of difference between eligibility list and seniority list.
My lord,
Sir, where is the junior engineers list, seniority list?
Seniority list is given by the side in the column itself. My lord, here your lordship.
No, in this petition name is not there because he is not, according to you, he is not eligible. Where is the senior list of junior engineer?
That is, my lord's annexure 3 capital A at page 25. Starts from page 25. That is cadre senior in the junior engineer. And from this cadre
in this senior list, where is the petition name?
Petitioner in the said seniority list, your lordship, petitioner number name figured at serial number 2578. In feeder cadre gradation list, your lordship, 2009. 2578, your lordship. Petitioner number 2 name figured at serial number 2806. J.
2578 for first petitioner.
Lordship.
Second petitioner.
Second petitioner, Lordship, Dilip Kumar Sharma, seniority position of 2806. 2806.
Then third is Milos Ratan Kumar at 2920 लिखा हुआ है.
जी. Lordship, I have annexed a chart as in
Number 3.
Serial number 3, Lordship.
Sorry, petition number 3.
3 at 2920.
2920.
Lordship. Petitioner number 4 is 3036. 3060. 3060. Sorry. 3060. Petitioner number 5 is 3014.
3014.
Lordship. Petitioner number 6 name is 3062. Lordship. And all the Lordship junior engineer list in this Lordship admittedly juniors to the petitioner. Lordship.
No, the persons who were promoted.
Persons.
Their names are below 3062.
Lordship.
3062.
3062. Lordship.
3062.
Lordship. Serial number. Serial number 17. Also kindly have looked to page 20. 25. Lordship. 25 in the counter affidavit. Serial number 17. Dhananjay Kumar. Their seniority position is 3077. Serial number 16. Their seniority position is 3075. Naval Kishore.
So 17 to 24 are juniors.
Lordship. 15, 16, 17, 18 and onwards, they are Lordship junior.
Some of them
junior.
Junior.
Lordship.
Now, as on Mr. State Council, as on 31/12/2008, the petitioners were not eligible.
No, petitioners were eligible, but among the eligible persons, a seniority list was prepared. That is annexure, my lords.
Where is the assessment? As on 31/12/2008, the petitioners were not eligible.
No, my lords may come to annexure 3, page 25, where a chart has been prepared.
No, where is the assessment?
Yes, assessment.
Assessment is required to be done as on 31/12/2008. Initial date is 31/12/2008 for the reasons that all these 31 persons have been promoted retrospectively with effect from 31/12/2008. So as on 31/12/2008, if the petitioners are not eligible, they are out.
My lords may kindly come to annexure 3. I may try to explain it, lords.
Annexure 3 of what?
Of the writ petition, page 21. This is the eligibility list.
No, eligibility list.
That gives also the seniority. Yes. My lords may kindly have a look. 24 to 2000. Now, my lords, next page. The lordships will see there is a chart. Now,
page 22.
Page, my lords, 22. Yes. Page 22. Now, my lords may see on the left side, here is given. Varsh 2003. My lords, you see on the left side?
Yes, 2003.
2003. Now, names of 3 persons are coming. Umesh Sharma, Naval Kishore.
No, this is only for namesake.
No.
2003.
Let me, my lords, how they have done it. Right or wrong, I am not saying. I am only saying how they have done it.
If you are promoted 31 persons in the year 2003 with reference to vacancies occurred in 2003, what you say is correct. They are not eligible.
if you are filling up those vacancies in the year 2008, 31st December 2008, they were eligible.
Well,
that's all. That is the issue.
Prevailing at that time was that the persons who had passed the AMIE examinations will not a separate eligibility seniority list, that is known as eligibility seniority list, is required to be prepared on the basis of the date of passing or year of passing. Now, year of passing, say 2003, that's how it was prepared. My lords may kindly say.
You are not understanding our what? Are you giving promotion to 31 persons from 2003? I am asking you. Show us. Show us your order.
Person who passed in 2003.
That cannot be, sir. Your argument cannot be accepted. Your argument would have been accepted if 31 persons were promoted in 2003.
Let me complete, my lords. Then, my lords, just kindly see to page 22. So, in 2003, my lords, 3 persons had passed the AMI examinations.
Yes.
So, their name came in 2003. Then 2004, persons who passed in the year 2004 AMI examination, which was the qualifying examination, their total number was, my lords, 35.
Yes.
Now, my lords, in 2005, persons who have passed the eligibility AMI examination, that is, my lords may kindly see on the next page. Page number, my lords, 23. My lords have seen. Yes. Then first name is of the petitioner, Dinesh Prasad Pratap Singh.
2005.
2005, because he passed the AMI eligibility examination in 2005. Petition number 2, Dilip Kumar Sharma. Petition number 3.
All right, I have understood.
Yes. Now, all the petitioners passed the AMI eligibility examination in 2005 or later. Persons who had passed the eligibility examination prior to 2005, that I have listed. Now, the rule prevailing as of that date means as of the year 2003, 4, 5, 6, 7, Milots and 8. Milots, the rule prevailing was that persons who have passed the examinations earlier, they will rank senior. Now, on that basis, it was prepared, and persons for the year who has passed earlier, they have been, Milots, on this basis of seniority, they have been granted promotion. Now, 2005 has not come. He could have got promotion, but unfortunately, Milots, because the Supreme Court has stayed all promotions, therefore, Milots. So, therefore, though it was being considered in 2008 cumulative effect, but if your lordships will see the rule prevailing in 2003 with respect to year-wise vacancies, 2004, 2005, 2006 and 2007, even till 2008, Milots, the vacancies were to be filled up on the basis of seniority of AMI. That was the rule. The rule altered subsequently in 2008, whereby it said that cadre seniority will be taken. Now, my lords, the grievance of the petitioner is that you apply that 2008 rule. Forget about 1998 rule.
Yes, they have to.
Well,
their stand is
whatever may be, lords. But what we have done is that we have taken the vacancies, the year of vacancies, and the rule prevailing in that year. So in 2003, we ought to have filled up in 2003. That, of course, could not be done. In 2004 also, 5, 6, 7, it could not be filled up because of bifurcation of the state, and cadre was being divided between Jharkhand and Bihar. So the state of Jharkhand was created, this bifurcation and cadre division was in fact finalized in 2008. Now, after 2008, the vacancies was crystallized. That year-wise, how much vacancies comes to Bihar. Now, on that basis, the rule which was prevailing in 1998, I may not read the rule so you want, but in that but I can place before your lordships 2 judgments. Now, this was the issue which was categorically decided by the division bench, where how the seniority has to be fixed for the purposes of granting promotion under AMI quota. There it said that the seniority has to be on the basis of persons who have passed the AMI from the year because that was the privilege.
You are repeating the same thing.
That is the reason why, my lord, that was done.
That's all.
That's all.
Yes, you want to say something? Yes. Take on.
And Lord, secondly, my learned friend wants that the whatever promotions has been given or the seniority has been given, that should be annulled. And Lord, in this place, Lord, the petitioners who have not been granted promotion.
Sir, if the petitioners are eligible for promotion in the year 2000, 31/12/2008, they are eligible. They should be promoted if they are senior.
In cadre senior.
Huh?
In junior engineer cadre. Yes, of course.
Junior engineer, they are rightly or wrongly senior. They have not passed AMIA before 2005. If you have filled up these vacancies prior to 2005, what you say is correct. They are not eligible. But you are filling up those vacancies in 2000, 31/12/2008. As on that date, they were eligible.
But we applied the rule prevailing on
that. Is not permissible. Even recently, Apex Court in the case of State of Himachal Pradesh versus Rajkumar in 2023 held that earlier vacancy cannot be carried out and fill up in accordance with old rule. Who are the contesting respondents?
Then the persons will have to be given notice because those persons will.
Notice has not been given.
No.
Not appeared, Your Lordship. Notices have been issued and appears.
They are party to the suit.
Lordship. Appears, Your Lordship.
Appears correct.
Well, respondent number, my lords, 6 onwards, 6 to, my lords, 32.
6 to 32.
My lords.
Lordship, Mr. Arvind Bajrangi Lal respond appear for private responders. Plus several councillors Sanjay Pandey, Lordship Bajrangi Lal, Dhurendra Kumar, Vikas Kumar, Nadim, Lordship. These are the appeared on behalf of respondents, Lordship.
The registry is hereby directed to clarify as to whether Reformer 6 to 32 have been served or not, except Reformer 6, who is Reformer 8, who is represented by Mr. So and so Council, or in the alternative to give an opportunity to contesting respondents. Read this matter on so and so. Today, the counsel for the respondent filed supplementary counter affidavit on behalf of respondent number 2
perusal of the supplementary affidavit, it is evident that even though vacancies have been calculated from 2003, dash 11 vacancies, 2004 dash 05, 2005 01, 2006 00, 2007 04, 2008 dash 31. Overall, thus 52 vacancies. However, they have filled up 31 vacancies. By promoting eligible junior engineer to the post of assistant engineer on 1/4/2010. Hereafter, to the tendency of the present petition, before that, within bracket, prospectively, the further date of promotion has been modified from 1/4/2010 to 31/12/2008 on 22/10/2018.